The court will now take up Beach Boulevard, LLC versus Live Oak Banking Company. You may proceed, counsel.
Good morning, Your Honors. May it please the court. I'm Richard Timms. I represent 1944 Beach Boulevard, LLC, who's the appellant in this matter. I was last here maybe 35, 36 years ago working as an intern for Justice Parquette. Don't know that I ever saw the inside of this courtroom. They kept us in the library or in the musty basement working on the jurisdictional
briefs. Welcome back.
Yeah. It's good to see two of my classmates on this panel. We're not here to talk about the musty basement, obviously. We're here to look at an appeal of we're trying to seek determination of whether the appellee's asserted lien on Beach Boulevard's assets is properly perfected as a result of their failure to follow the protocols that are outlined in Section 679.5021 Florida statute when they filed a UCC-1 financing statement using an abbreviation of my client's name. This case
that was a mistake.
That was a mistake, and I think that is admitted. The 11th Circuit has found this to be an important question for the court to decide, and certainly this is on the speaking tour right now. When you go to the business law section, they're paying attention to it. Before I address the legal issues, I want to make sure that the court understands how this plays out in the real-world context. Whenever a lender makes a loan to a secured by receivables, inventory, other personal property, there are usually three instruments. There's the note that evidences the obligation to pay. There's the security agreement, which is the pledge of the collateral. Sometimes those two can be combined, but those are the two things signed by the debtor. And the third item is a UCC-1 financing statement, which is it's usually filed by the lender with the appropriate authority just to put the world on notice that somebody's claiming a lien on that asset. Having that document filed properly is important because it establishes lien priority vis-a-vis other creditors, and it also, that's on a first to file, first lien right basis, and having it filed of record also alerts potential prospective purchasers of the debtor's assets that hey, these assets may be encumbered. And so it's very important that the notice of the lien be properly filed and published so that subsequent purchasers and lenders don't find themselves faced with an unknown lien. I mentioned that in Florida, financing statements...
Let me direct you. Would you agree that the outcome of this case hinges on the safe harbor provision, ultimately?
It's all about the safe harbor provision.
And I think maybe the most critical language in there is figuring out what is the standard search logic of the filing office, and that language that says, if any. So I think the commercial law amicus initiative framed that well and really focused on that in their amicus brief. And I'm wondering, there was no response to the amicus brief from either party, but it seems like if the search in Florida is viewed as bringing up the whole list, then that wouldn't be a search logic. And the if any has to mean something. So it means that there are electronic systems that will give some result that don't fall under the search logic provision in this context, right?
Well, I take
a couple
exception
questions.
to the amicus brief that it says there's no search logic. I think in our A15, our appendix, the Florida has adopted the compact name as its search logic. And so there is no definition of search logic in the statute, but what we have is a procedure. The financing statement is only effective if it identifies the name of the debtor. It has the name of the debtor, has the lender, and the collateral. The name of the debtor is only sufficient if you use the organic name filed of the entity as filed with the Secretary of State. You then put that in. If you follow those procedures, I promise you, that lien will show up if somebody, a searcher, uses that same protocol and searches under that name. It shows up. And the intent of
when you say it shows up, you're saying it will show up in the search at the top of the first page that's displayed. Is that what you mean?
The liens of, yes, the 20 page.
Right. I mean,
20
and
per page,
it may extend beyond the first page because
Right.
because of the number of financing statements that may have been filed.
Right. And if you understand the briefs and read them, the whole goal of putting this system in place was to shift the burden and get rid of all these decisions on how far back you got to go, how far forward you got to go, what variations of the name should you search under. All of those items that just led to all kinds of crazy results. Most of the time, those results were, based on the judge's opinion of equity.
But I'm sorry to interrupt you, but I think that this gets to the heart of what Justice Lawson is asking about, which is, so the first point is the term in the statute, the court has to give that meaning. The agency can't just say whatever we call is a search logic is a search logic. They couldn't just hand you, they couldn't just say our search logic is to print out our entire list and hand it to you and we can assure you that you will find your thing in here, right? And so I think his point is that by having a quote unquote search logic that doesn't really winnow the results, that essentially you're right back in the same spot of where all this discretion of, do you have to go a page back, do you have to go a page forward, et cetera, et cetera. And so really, I think the amicus brief makes a compelling point that essentially we're dead on arrival because in Florida, notwithstanding what the agency says, and I know, constitutionally we don't have to defer to them if they, have an unreasonable sort of interpretation of the statute. And so really there is effectively no safe harbor here.
Which means that you have to put in the exact name. You have to use
that
the
wouldn't bother
code.
you.
That wouldn't.
To me, I think that's a red herring, honestly. Why?
Well, it's not a red. I think the result isn't so much that you have to put in the exact name, is that you have to get it right when you file the thing, and if you didn't, then it's basically a strict liability sort of, no margin for error kind of situation. And if Florida wants to have a real search logic that does winnow the search, then the safe harbor would kick into existence.
Well, I would say this: there's only one person that can control what's input, and that's the lender, and that's what the legislature intended to do. And the drafters of UCC, let's put the risk of a misfiling on one person. And my point is, why have a statutory safe harbor if the courts are going to ignore it? Why have it? And I don't think.
Well, but the conditions for it have to exist, and the condition of a standard search logic is part of the requirement, right?
It's not a defined term. So
I understand that. I understand that.
To me,
and I understand that we can there can be differences of opinion about it, but. The amicus brief, I think, makes some compelling points about how this operates. Because if I understand correctly, there's a hypothetical on page 25 of the amicus brief, where if I'm understanding, if it doesn't show up on the first page, okay, that it is produced by this surge. Then it's not going to be considered perfected, right?
That's It's unless,
Unless-
you're right, yes, absolutely,
Well,
under
unless,
the
of
safe
course,
harbor.
unless, of course, you get to the end of the first page, and you have, and then you have the name is correct, and then it goes on to the next page.
Yeah.
Okay. But the problem with saying if it's not on that page, then it's not perfected, is that can change. Something could be not perfected and then become perfected because of financing statements expiring and going off. Am I wrong about that?
No, I think the.
Am I wrong about that?
No, you're not. But I don't.
Because that's the hypothetical, and that seems to me to create kind of a very anomalous situation.
Well, the amicus does a great job of pointing out, criticizing the system, but I don't think that's necessary because, to your point, well, get back to where we start. Who bears the risk of filing it correctly?
This argument does not hurt you.
I know, but you can have.
So it's not. I understand about who bears the risk, and that this is like ultimately they got to get the name right.
They get it right, and they follow what the statute lays out. This system implements it. No, it's not a Google search with algorithms that are predictive of what other variations may exist. I don't think there's any requirement of that. That would actually shift the risk to the programmer to make sure that he's got all variations thought through. But
doesn't the subsection, the safe harbor provision, contemplates that there may not be a standard search logic? Because it says, if any. So the legislature says, okay, if it's here, then this is what happens.
Yes,
but that implies that if it's not here, and it may not be, even though there's a computer search, there may not be a logic, then that provision just doesn't help the other side.
And that's the point here, is that the legislator wanted to get away from this, all the variations, all the problems with search engines, all that. Just said this is the simple, hard, fast rules. And when a judge in this instance says, well, they're only one page behind, maybe that's just kind of inequitable, is what's basically happened. He's taken away the safe harbor. He's ignoring it. And he's injecting the very same uncertainty that the legislature and the UCC drafters intended to get around. Our search engine in Florida will evolve over time, I'm sure, as computers get better. But right now, this is what we have, and it works. It works. And it implements the legislative intent. You follow these rules, and by the way, there's no safe harbor for a searcher. If they input the wrong name, they're out of luck. So this safe harbor appropriately balances those risks on both sides, because there's only one person who controls it. I keep coming back to that point, and I think in this case, what's happened is that they have they're injecting the same uncertainty. I don't have any qualms with our system here, but now to start attacking the methodology, getting into algorithms and that consideration of all those type of things, when we do have something.
But you haven't answered my question, I don't think, about how something can be on one day not perfected and on another day perfected.
That's luck, but it all.
Oh, okay, it's just luck. It's going to depend on luck. That's quite a system.
No, I say no. You're perfected if you follow the protocols. But under the safe harbor,
I'm talking about this example. If you're looking at what's arrayed on that first page, that can change over time.
Exactly.
And then a name that's not precisely right might show up on that page on one day when it wouldn't show up on it another day because of other things that have fallen off.
Or the agency changes its convention, and instead of outputting 20 names at a time, guess what? Our new default is it outputs 50 names at a time. That's just the default. You would laugh at it is luck. I mean, because it is going to be shifting by virtue of somebody satisfying a lien, taking it off, and now your list is going to change. But aren't we looking at lien perfection at the time you made the loan, or the time? Somebody should be.
But it's got to be replicable. You've got to be. Well, I don't know.
You look at the time when I make the loan, I should be printing off this, this sheet, show these are the 20, just to show that this is what appeared that day. That would be the appropriate thing. If I'm a subsequent searcher making a loan to someone based on what I'm seeing at the Secretary of State's website, that's prudent. That's what they should be doing. But I think it is a little bit random of whether you're going to be on that list one day and not. But
so you started by saying that the whole scheme depended on the filer. You put the onus on the filer to perfect its lien. And now your argument is, it's just luck, whether it's perfected or not.
No. The onus is always on that never changes. I would say for an erroneous, I think Justice Kennedy's question was if you have an erroneous financing statement, it may or may not appear on that list of 20 depending on the day. And I agree with him that can happen, but that to me becomes evidentiary about whether or not it was perfected on the date in question. That's evidentiary. That doesn't mean that you don't enforce this.
There's not much logic in the search logic like that.
It's not perfect, but it does. If you follow it, your lien's perfected. The safe harbor, you prove that at some given point in time it was on the list. You're entitled to the safe harbor. If you file something erroneous, you run the risk that it's not on that top 20. You also run the risk that some new financing statements get in ahead of you, push you off that list. But who should bear that risk?
Yeah, I don't know why you're defending it. I mean, this is a rare opportunity for us to do something to make the academic commentariat happy, to actually make the law more rational.
Is that the role of the judiciary? Is my question. Isn't that the legislature? And we're looking at the facts of this case. They didn't do it, and it didn't appear on the top 20. It appeared before it, and it's in the facts of this case. There was no lien perfection. You can criticize the safe harbor or not, but
I don't think anybody's asked a question disagrees with that. Now, we may be persuaded otherwise when the opposing counsel speaks, but I don't think any of these questions have been unfriendly to your ultimate position.
No, I like the amicus brief because of the analysis there, but I think they're going off target because you circle back.
All right, you're in your rebuttal.
Okay.
You can keep going if you want to.
No, sir. Thank you.
All right. Counsel.
Good morning. May it please the court. My name is Ezra Scrivenage, and I represent the appellee Live Oak Banking. The court's very aware of the background of this case. It's very obvious. Just some main points. My client provided 2 loans totaling $5 million, and it was secured by 19 entities, one which is now the appellant in this case. All the loan documents, as was described by appellant's counsel, all listed 1944 Beach Boulevard with the word Boulevard abbreviated. And if the court reviews the attachments, there's even certifications from the borrower that's the correct name. With that said, I think it's important because I think it shows that all the parties agreed from the outset of this loan that that was the name of this entity.
Counsel, could you?
This is about the rights of third parties.
Yes, the third party, in a way, I understand that. It is weird in that the third party being the debtor in possession in the Chapter 11 is also the borrower.
I'm sorry, Justice Roseanne says.
It's just, could you kind of address what we've been talking about,
Yes.
about whether the safe harbor provision is even a workable excuse, so to speak, if there's no search logic employed by the department?
So I agree that Florida's search system is terrible. I think a lot of people that have discussed this, we understand it just isn't a good system. The assumption or opinion of amicus that there is no search logic at all is true as compared to other systems they're relating it to. With that being said, Florida is stuck with what we're stuck with at the moment. And for purposes of what we're here on today, it's up for this court to interpret this provision, the safe harbor provision, and I would also want to talk about another provision in the same statute, in a manner that reaches the result the statute's intended, but also reaches a result that's not absurd. And I think it's absurd the way this search system works. And the fact in this case is, when you type it in with the whole word Boulevard spelt out in the search system, it pops up the first entry on the next page, because it's all alphabetical. So it's a simple one-click either way, and it could easily pop up when you're dealing with an abbreviation.
Let's start with just 50311.
Yes.
And so that's the starting provision of the statute, and it says that a financing statement sufficiently provides the name of the debtor only if it provides the name that is stated to be the registered organization's name on the public organic record most recently filed with or enacted, and it goes on. But you would agree that that requirement was not met because of the abbreviation, correct? Everybody agrees with that?
Correct.
Okay.
Correct.
Okay.
I would agree with that. And then I would then just bring up the section that the safe harbor's in, which is 679-5061. And subsection 1 of that refers to substantial compliance and minor errors and omissions, which there is contemplated if the safe harbor, as we're talking about, is illusory.
And that provision is perplexing, because it starts off by saying that minor errors don't matter in determining whether it's seriously misleading, but then it very plainly says that if the financing statement fails to sufficiently provide the name of the debtor in accordance with 50311, then it is seriously misleading. And so we've already talked about that, and so even though it says minor differences don't matter, it takes you back and says that they actually do, in very plain language, correct?
They do.
Okay, and then that takes you to the safe harbor provision to allow you some opportunity to have a filing statement that's valid, even if you didn't get the name absolutely correct, if there is a search logic.
Yes.
Okay.
That's exactly. It all boils down to that provision is based upon a real search system with search logic, which Florida doesn't have. And I think since it's illusory, that the safe harbor in subsection 3 can't apply to Florida, right? Because we don't have it. So what do we have? We have subsection 1. I think this court in the past, in other issues, when it comes to notice, it's substantial compliance. Here, there was definitely substantial compliance when you look at the underlying facts of this case. And if you also look at the two cases that both the Middle District Bankruptcy Court, the District Court sitting its appellate capacity, followed.
Counsel, I mean, if subsection 3 isn't operative because we don't have the standard search logic, you're not just thrown back on subsection 1, you're thrown back on subsection 2, which says financing statement that fails sufficiently to provide the name of the debtor in accordance with that, and another section you know about, is seriously misleading. And I don't see how, if you following that, I mean, if subsection 3, if you have no refuge in subsection 3, it just seems like in these circumstances where you made the mistake, your client made the mistake of using the abbreviation, which is forbidden,
right? No
good, that under subsection 2 you lose.
And that is one of the interpretations that could be taken. And what we're proposing is that's absurd. It would be very unreasonable, the result, in Florida especially, because, you're dealing with a system that the UCC provision didn't envision when it was written. It was just adopted here in Florida blindly without any sort of view of what our system is. And it could change tomorrow, and all of a sudden we're perfected, and everything changes. But it's not that way. So really the relief we're asking from this court is to interpret this statute in a manner that's going to be reasonable in the facts of this case and fair to all the parties.
Well, I don't understand what's reasonable about requiring that the creditor use the correct name of the debtor. I mean, that is a very simple, crystal clear requirement. And there are resources. I mean, you can go on the website at the Secretary of State's office and you can look it up, right?
Agreed.
And apparently somebody just didn't do that. They decided they would, I don't know, I mean, it's hard to understand dealing with millions of dollars in money, but mistakes happen.
I'm sorry, Keith. Are you making a reliance argument on the certifications that they delivered?
Well, it's a good point you brought up. So those issues were never addressed by the lower courts at all. But those are asserted defenses. There is a waiver estoppel reliance issue upon assertions. Now, I don't know if the court wants to go into that because I don't know if that's before the court. It's more of interpreting the statute, but I think eventually if we get back down to the other courts, ultimately the court would have to look at that component as well. But yes, that's a good point. So, I'm just asking the court basically, given the reliance, I guess, and the way our system works, there really is no workaround. There really is no safe harbor unless the court follows the court's opinions, the lower court's opinions, the middle district and the southern. And I understand that southern district opinion, the decision, the holding doesn't help me, but the reasoning behind it and how they approve of the middle district helps our client. So let me see if I have any other points, if the court doesn't have any other questions for me. I did want to point out, but again, this applies if we're looking at the safe harbor, but they talk a lot about the revisions did away with a reasonable search requirement. It did. I agree with that. You put in the right name, but there's a two-step process when you're searching for UCC financing statements. You got your search, and then you got your actual review of the documents. And I don't believe the revision did away with the fact that a searcher's got to use some sort of reasonable common sense in reviewing results, especially when you're only getting 20, and you're dealing with a loan that has 19 entities that secure it. So that's going to be 19 right there just on one loan times 2. So I think at some point the button's got to be pushed. Forward or backwards, how many times, no one knows. And I don't know if, I'm sure a lot of people care, just nobody knows. So, I would propose that, yeah, they did away with the reasonable search, but you still have to, there still is that reasonable examination step that's got to be taken. And I think that changes a lot. I talked about the cases. I really have nothing further. We discussed the amicus and the 800-pound gorilla in the room they pointed out, which is the fact our search system has no search logic in Florida. And with that being said, I have no further to present at this time.
Right. Thank you. Rebuttal.
Thank you, Your Honor. As Justice Lawson pointed out, the statute 679-50613 doesn't require a search logic. And we can't just ignore that specific wording, take it out of the statute. And I think with amicus and live oak and some of the questioning here today suggests, well, should there be one? Maybe there should. It's just not required under this statute presently. And that's what we need to come back to. And again, we're implementing. I don't have the qualms with the system that others might. I think it works fine. We rely on it when we make loans, when we do our searches. When I'm a Chapter 11 specialist. When we're trying to determine what liens are out there, we look at that. And to your question earlier, there are 18 other debtors with collateral pledged to them. We, as a debtor in possession, that we are basically fiduciaries for the unsecured creditors and such. So this reliance issues and all that, that's way beyond what's here before the court. But just so you know that this is customary for a debtor to have these rights to fulfill its fiduciary duties to others.
But the point here is that they're not just reliance interest between the parties in terms of representations that were made, but this is about the reliance interest of third parties.
Correct. And there just has to be this level of certainty, which I think exists if you follow the statute. And it wasn't followed in this instance. no matter who's at fault, but the one person who could have checked the Secretary of State's records, got the correct name, and put it on the financing statement, didn't do it right. And it's unfortunate, but we balanced the risk. Searchers who input the wrong name can take it on the chin too. And so it's a question, this balance, the statutory scheme, the Uniform Law Commissioners, they've thought it out. We adopted it in Florida. It works. Maybe it's for the legislature to decide if they want to define add as a search logic, but I'm not real good with administrative law issues, but we have adopted a search logic, imperfect as some may believe. So, thank you.
All right. We thank you both for your arguments in this case today. And the court will now take a recess of about 10 minutes before we take up the final case on the docket.